As you're going through your divorce or custody fight, you're talking to your soon-to-be ex, and you're trying to work things out, you're trying to be amicable, and as you're going through this process, it seems like you've gotten to an agreement. You have an oral discussion about what's going to happen, who's going to take what property, or how you're going to deal with issues related to the children. It seems like you're there. Maybe you've even sent over an email and said, hey, is this the basic terms of our agreement? He or she said, yeah, that's what we're going to agree to. So you go out, you write it up, you put it onto a nice formal piece of paper, you have a notary seal on there and everything, and you take it to your soon-to-be ex and say, hey, can you sign this so we can make it all official? And they look at it and they say, you know what, screw you, I'm backing out of our agreement, I want to go to court instead of agreeing to everything. Are you stuck or is this person bound? I'm Arizona attorney David Enevoldson, and in this video I want to talk to you a little bit about agreements in family court in Arizona cases. Now, generally speaking, agreements, once a case is going, are governed by Rule 69 of the Rules of Family Law Procedure in Arizona. And what Rule 69 says, as relevant to this particular video, is that if you have an agreement between the parties and it's in writing, then that can become binding on both the parties and the court. Now, there's some exceptions to that. There's also case law that talks about that you need a, quote, manifestation of assent between the two parties in order to make it binding. So it has to be terms of the agreement in writing in some fashion, and you have to have people saying, I agree to that. Simple example of that could be an email exchange where somebody says, here are the basic terms of the agreement. Do you agree to this? Other person says, yep, I agree. You've got an agreement that's binding. It doesn't have to be signed, doesn't have to be notarized, doesn't have to be anything crazy official. You can have something just through emails, through text messages. So you should be extremely careful about what you are saying and agreeing to in any sort of writing medium with the other party. Now, there are certain exceptions to that. For example, one of those is that these agreements are binding on the court unless, if you're dealing with child issues, the agreement is not in the best interest of the child, in which case the court can set aside the agreement. Also, if you have an agreement that is just patently unfair, the court can set that aside as well. So if you've got some really extreme situation, which is generally what it requires to get the court to back out of an agreement, then the court can say, no, this doesn't make sense, you guys aren't going to go into this agreement. But if the court finds that it is in the best interest of the children and that the agreement is generally fair, everybody's stuck. The court's stuck, you're stuck, the other party's stuck, unless you agree to change it. So be super careful about what you say in writing to the other party. Now, Rule 69 also has some other situations in which you can become bound, and those are things like if you're in front of a mediator and there's a recording device out and you put the agreement on the record in front of the mediator. Another example is if you are in open court and you put an agreement on the record while you're in open court, even though it's an oral agreement, that's going to be binding. Now, some other situations where people run into very often is if you have an oral agreement, say you've got a recording of the oral agreement, but there's no open court, there's no mediator, nothing like that, is that going to be binding? And generally speaking, no, it isn't. So you need to have something in writing in some fashion or in open court in front of a mediator, something like that, in order to have a binding agreement. That said, there are some times when having these conversations on record can speak to some of the circumstances that are going around. Maybe you can talk about attorney's fees if you're like got somebody entering agreements and then backing out of them and it's just becoming this big mess. But as a general rule of thumb, at least the agreement itself is not binding. One other cautionary note is that if you are going through this and you have an agreement in writing and you're putting out all the terms of the agreement down on paper and you're trying to get this locked into, I highly, highly recommend that you talk to an attorney before you write this thing up and before you try to get the other party to agree to it. Even if you can just talk to an attorney for a few minutes to kind of have them look over it, pay them for a few minutes of their time to look over this agreement just to review it, because one of the big problems I see all the time is when people have agreements, they try to write them out, they may be completely binding, but they're confusing. And you don't know exactly what the terms are, or there's something that's subject to numerous interpretations, or there's something that obvious that was left out that maybe an attorney would notice right away. And that ambiguity can kill the agreement. So even if it is binding, but nobody knows what the heck the real positions were because everybody had different ideas in their minds and you look at the agreement itself and it's really confusing, it could be completely useless. So if you are going to write out an agreement, have an attorney look at it, please, just to make sure that you're getting all the basics in there and you've got everything protected. With this and any other situation, if you are going through a family court case, I highly recommend that you just talk to an attorney, period, just to make sure that you know all your basic rights and obligations that go on with this process, and just make sure you're not making some major error.